Thank you very much to everyone for coming. So for those of you that don't know me, my name is Faheem Anwar. I'm a barrister at Greenway. Been around for about, getting close to 6 years now, although it doesn't feel that way. I practice predominantly in employment, industrial, and building and construction. And today I'll be presenting with Josh Martin, one of the other barristers at Greenway, who's again another specialist in employment and industrial law. So, as you can tell from the slide, our topic today is industrial action. And obviously this has been a very topical issue of late. You can't really open up the papers without reading about it. It's a very broad topic, and this presentation is not intended to cover exhaustively all aspects of it. We're actually focusing pretty narrowly on two provisions of the Fair Work Act, which deal with, firstly, suspension and termination of industrial action, which is what I'll talk about. And then after I'm done, Josh, which deals with section 424 of the Fair Work Act. And then after I'm done, Josh will talk to you about section 425. Now, starting with section 424, I'm sure most of you don't know sections of the Fair Work Act by memory, although some of you might. The section is up on the slides. Critically, what that does is, in order to suspend or termination, fundamentally what you need to show is what's in subsection 1A and B, so that industrial action is either being engaged in or it's being threatened, impending, or probable. So that's the first element. And then if you satisfy that element, which is generally pretty easy to do, you need to either show that it is threatening or would threaten to endanger the life, the personal safety, or health, welfare of the population or part of it. So that's one element, or alternatively, you can show it is threatening or would threaten to cause significant damage to the Australian economy or some part of it. Now, what I'll do is I'll start by just outlining some sort of very basic principles. Those of you practicing in this area would probably be very familiar with these principles, but it's really more for people who don't really have a background in the area. And then I'll focus on two cases that have happened, I think, in the last 12, probably close to the last 6 to 8 months, to full bench decision, which I think are worthy of note. Now, just as a refresher, so in terms of proving threats to life, personal safety, health, and welfare, I've realized I've printed off my notes in far too small a writing and I'm too old to read it, so I'll have a look at the slides. So essentially, in order to prove that, you need to prove, it's not enough to prove that there is a threat, or in other words, that a threat is possible. You need something more than that. The threat needs to be probable. So that's the first thing to bear in mind. Now, in terms of the level of the threat, it doesn't need to be life-threatening on the one hand, but equally, it can't be a mere inconvenience. So it's sort of really somewhere between those two boundaries. Again, as the authorities say, it must expose the population or part of it to some degree of danger. And in this context, population, as you would expect, means everyone in Australia, and part of it means a collective. Now, it's important to understand, I think the authorities make it clear, one individual is not a part of a population, although I think grammatically they are. But in this case, you need the analysis is a collective analysis. It's not based on individual analysis. I think that's the critical point to bear in mind. So I guess with those very basic principles out of the way, the first case I want to discuss is a full bench decision of CEPU and Transgrid. Now, I mean, Transgrid, for those of you that don't know, they are the operator of the high voltage electricity network in New South Wales and ACT. And they were undergoing, there was some industrial action happening as part of the bargaining process for their EBA. Now, one of the common practice when there is a fight about whether or not there is a threat to life, personal safety, health and welfare is for the union concerned to give a safety undertaking of some sort. And that's, in fact, it would be very, in my experience, almost unheard of for that not to happen. And the first case that I will talk about really just deals with the effect of the safety undertaking and how that's to be treated. Now, in that case, there was a safety commitment. The safety commitment's on the slide, so I won't read it out. But the critical point is it was a commitment to temporarily suspend any kind of industrial action to undertake emergency work or work that was work affected by what's called a declared incident, and those terms were defined in the commitment. Now, this proceeding had a bit of a checkered history, so what ended up happening, even though that commitment was notified, there was a fair bit of back and forth between the parties in terms of whether or not particular things satisfied that definition, basically. Now, I think in each case the work was ultimately done, but it was not done as quickly as the employer would have liked it to have been done. Now, and I suppose, to be fair, I think from memory in some of the cases it did take a long time, and we're talking sort of close to a month from memory. Now, so Transgrid's position was that these incidents were, firstly, the commitment was not being complied with. The back and forth was not consistent with the commitment, and they were arguing that it was threatening blackouts, essentially. Now, the first time around, Transgrid was successful in the first instance, and the Commission actually found that the actions of the union they disclosed impermissible attempt to block and or delay the operation of the commitment, basically. Now, that first decision was overturned by the full bench. Again, new notices were issued, and again, there was a second application. And again, in the first instance, an order was made suspending the industrial action. And I think the critical finding of the Commission in that decision was the action would threaten to endanger the life, personal safety, or health or welfare of the population or part of it, because a large number of employees of Transgrid who had given the safety commitment would be unlikely to comply with the commitment. So that's really where things stood. The union appealed that decision, and that's really the decision I'm concerned with. Now, what the full bench held in that decision, the appeal was allowed. Now, the full bench held that the Deputy President was satisfied, Section 424 requirements were satisfied only on the basis that employees of Transgrid would not comply with the safety undertaking that was given. Now, the critical thing there to note is the full bench held under that section, the inquiry focuses on the effect of the protected industrial action. And when you have employees who are going beyond the bounds of what is in the safety commitment that was notified, they're actually going beyond the ambit of what is a protected industrial action. They're going into the territory of unprotected industrial action. And the full bench held that if the CPU members were to take industrial action that didn't comply with the notices, their actions would be unprotected. And so for the purposes of determining whether or not 424 was satisfied, you don't have regard to risks associated with unprotected industrial action. you focus on what's been notified as the protected industrial action and focus on it, that's consequence. And again, I think that's notable because there are a couple of older decisions which Transgrid did rely on, which sort of, perhaps not as directly, but does sort of suggest the alternative position is correct. So in some sense, I mean, it outlines the position clearly. And importantly for practitioners, I think in my experience often, there is perhaps, certainly amongst employers, some degree of skepticism about the utility of some of these safety commitments. Now, I think the effect of this decision is if there is any concern about it, a clear decision needs to be made as to what the course of action is going to be. If the concern is, well, someone's not going to comply with the safety commitment and that causes risk, the appropriate course of action is to stop the unprotected industrial action under Section 418, I think it is. Whereas if you've got a course of action under Section 424, the focus is very much on, okay, what are the risks associated with what has actually been notified? And I think I have, so I've dealt with that, I think. So that's the first decision I wanted to talk about. The second decision I'll talk about, and that again happened, I think, in the last 6 months or so, that's the full bench's decision of CEPU and Wilma Sugar. I think it's entirely coincidental that I've picked 2 CEPU decisions. I wouldn't read too much into that. So that's a decision about Wilma Sugar, which is a operator of sugar mills in Queensland. Now, they are I was surprised to learn that they are actually they're responsible for production of approximately 50% of the sugar produced in Australia. So they represent a pretty significant part of the Australian sugar industry. Now, again, I mean, there was industrial action taking place in the context of bargaining. And in that case, the relevant industrial action was for 1-hour stoppages. Now, one of the quirks of the sugar industry, and if anyone's interested in learning sugar industry, this judgment is a bit of a riveting read. So one of the things that happens with sugar is you need to sort of harvest it and process it within a particular time. Apparently, when the rainy season hits, the sugar content of sugarcane reduces. So if you don't, I guess, harvest and process the sugar before the rainy season starts, effectively the sugarcane becomes unusable. So one of the employer had put his case and their evidence on the basis that as a result of the industrial action, and in particular industrial action in combination with other things that might happen, so things like inclement weather or usual maintenance of machinery, there was a real risk that they're not going to be able to process all the sugarcane before the season was completed, and as a result, they would suffer loss. Now, so in the first instance, the Commission made an order suspending the industrial action for 6 weeks. Before I take you through some of the key points, I think it's probably worth spending a minute just trying to understand the first instance decision. Now, the Deputy President accepted the evidence given by Wilma Sugar's general manager that the loss caused by the industrial action, so that's direct loss. A direct loss of revenue for Wilma Sugar was going to be about 26 million. As I say, that was calculated on the basis that there was a real risk because of the industrial action. It's going to push the harvesting into the wet season, and that would mean some of the sugarcane would not be able to be harvested and processed. Now, In addition, there was a there was a pretty hot debate about whether there was any broader economic impact. And what Wilma Sugar argued essentially is that there is sort of flow-on, so-called ripple effects into the economy. So if there's a bad sugar harvest, that has flow-on effects for people like farmers and sort of broad effects to regional economy and so on, because it's very concentrated in northern Queensland. Now, on that issue, the Deputy President accepted that the ripple effect needed to be taken into account. Now, there was a big debate about whether the expert report should have been admitted or not. I'm just going to put that issue to one side, except to note that ultimately full bench decided it should not have actually been admitted because it didn't properly disclose the reasoning of the expert evidence. But in any event, in the first instance, she did admit the report, and she accepted the broad proposition that you need to take into account the broader ripple effect. However, because of the shortcomings of the evidence, she didn't adopt any of the figures that the expert had proposed, and instead she adopted a multiplier of 0.3, which she described as a conservative multiplier. So if you apply that multiplier, you then end up with a loss of approximately 34 million. And then she concluded that, well, 34 million is a significant impact into the Australian economy, or part of it. So that was essentially her reasoning process. Now, this decision, the full bench's decision, set out some pretty important principles in this area. So the first one relates to what is significant impact. Now, the full bench decided that question of whether the protected action has threatened or is threatening to cause significant damage to the Australian economy cannot be answered by simply estimating the likely economic impact as a monetary figure and then saying that that figure is a very large amount. And the critical thing that you need to do is that the significance of the damage has to be assessed in the context of and by reference to either the Australian economy as a whole or an important part of the Australian economy that's subject to the threat. So in other words, it's not enough just to calculate how much the loss is. You need to put that into the context of the Australian economy. And I think there's certainly a series of first instance decisions that had happened where that wasn't necessarily always being done. And the full bench sort of observed that the quantum of financial loss may be significant in one context, but not significant in other contexts. So, for example, they looked at the fact that even if you accept that the loss was $34 million in this case, the evidence suggested that the total sugar manufacturing revenue in Australia was $3.6 billion. That's a number that surprised me, I must say. But 34 million, when you put it into the context of just even the sugar industry, is actually all of a sudden not such a big number. And that's the point full bench was making. It's not enough just to look at the loss. You need to look at it, in the context of the Australian economy, context of the industry, and so on. So I think that's the first principle that comes out of this decision. The second principle that comes out of this full bench's decision is that you need to grapple with the contingency. Now, in this case, whilst it was possible that you might not get the harvest done by the start of the wet season, on the other hand, it was also equally possible that that might all be fine, notwithstanding the industrial action, you would get it all done and there was no loss. Now, in the first instance decision, there was an acknowledgement that there was some contingency, but then in assessing the economic or quantifying the economic impact, that wasn't really grappled with. And the full bench said again, that's something you need to grapple with somehow. Now, they weren't very clear as to, how you would do that, whether you just sort of discount the loss amount by a certain amount to take into account a contingency. That might be one way of doing it. But what's pretty clear is if the loss is contingent, you can't just ignore it. You need to take that into account. And the third thing that this decision explored in a bit of detail is the fact that what does it mean when the section uses the expression the Australian economy or an important part of the Australian economy? Now, in most cases, the applicant will be focusing more on an important part of the Australian economy because it's easier to show that you're having a significant impact on a part of the economy rather than the economy as a whole. Very few things will have a significant impact on Australian economy as a whole. So what is meant by an important part of the Australian economy is quite important. Now, in that decision, just focusing again on what happened at first instance, it was found that there was a threat of significant damage to an important part of the economy. And the part of the economy, I think I've set it out in the paper, was described as Wilmar's contribution to the sugar industry. And the Deputy President looked at the evidence, and particularly she looked at the fact that, Wilmar was responsible for producing 50% of all sugar in Australia. Unsurprisingly, they're responsible for approximately 50% of total industry revenue. And also, in particular, their contribution to the Queensland economy was approximately 7.3% of the North Queensland region, so that's sort of around Cairns and those sorts of areas. 3.8% of GRP in the Mackay region, and approximately 2% of the GRP in far north Queensland as a whole. So it is an important part of the regional economy. And so based on those things, she decided that the part of the economy we're looking at is Wilmar's contribution to the sugar industry. And she ultimately decided that, the industrial action would have a significant impact on that part of the Australian economy. Now, what the full bench did not agree with that approach, and their view was the reference to Australian economy is to be understood as referring to a discrete and identifiable collection of businesses, workers, and consumers within the broader Australian economy. And it can be identified either on a geographical or a sector or an industry basis. So that's really what we are looking at. So, for example, the part of the Australian economy could mean the nation as a whole states, whole major cities, or whole industries. Critically, though, a single employer, even if they are a very large employer and even if they are sort of very geographically concentrated, that they are a very big part of a regional economy, a single employer could not be a part of Australian economy for the purposes of that section. So that said, in each case, so I think what that effectively means, and I'll sort of talk about this a little bit when I discuss the key takeaways from this case, but what this really means is you need to carefully think about, what is the part of the Australian economy that we are actually talking about here? And then demonstrate that part is that part actually important? Now, on the issue of whether or not part is important or not, there was unfortunately not a lot of guidance in this case. What the full bench decided is it's really a question of fact and degree based on the evidence in each case. But you do clearly need to identify the relevant part that we're dealing with, and that can't be a single employer. It has to be either geographic or industry based. So I think the key takeaway from this is I think it is going to make it more difficult, I think, to get an order under Section 4241D. I think that's probably the most obvious takeaway. In particular, I think the evidence to reach the threshold under that section is going to have to be pretty good to get over the threshold. I think it's not going to be enough for the applicant to show, I think as has often been the case, that, well, this is just going to cause a very significant monetary loss. You need to put the monetary loss into, you need to put on evidence which puts it into the context of either the Australian economy or a part of it, so the industry or, particular state, particular city and so on. And as I say, you need to sort of identify what the relevant parties and why that should be important. And then once you've done that, you need to show that, well, the loss that's occurring is significant for that part of the Australian economy. So I think that's all I propose to say. I'll hand over to Josh, who will talk to you about Section 425.
Thanks, Faheem. Right. So Section 425, again, another topical issue that has come out very recently. Those of you who've had the opportunity to read the Sydney Trains decision, or indeed impacted by the Sydney Trains decision. Some of you may be very happy about it, depending on your particular persuasion. Some of you might not be. It's a rarely invoked provision, particularly when you compare it to Section 424, which is very common for generally employers to bring. From my brief look through, scrambling through to prepare for today, I managed to come across about 25 decisions. I'm going to ask you a question later on, so just to keep in your mind, how many of those you think in which an order was suspended in respect of a cooling off period out of those 25? So I'll just come back to you later on. So again, just to bring up this provision, it's a rarely invoked provision, so it's worth stepping through it. This particular provision provides that the Commission must make an order suspending protected industrial action for a proposed enterprise agreement that it is being engaged in if the Fair Work Commission is satisfied that the suspension is appropriate, taking into account four key considerations. The first is whether the suspension would benefit the bargaining representatives for the agreement because it would assist in resolving the matters in issue. The second point is the duration of the protected industrial action. The third is whether it would be contrary to the public interest or inconsistent with the objects of the Act, and any other matters the Commission considers relevant. And you'll see as the bottom of the slide, I've made reference to that decision. That is the most recent decision in the citation there. What the full bench held in that case as to whether it would be appropriate. Obviously, that invites an evaluative judgment, which is discretionary in nature. Consideration of appropriateness requires you to consider those four elements, and each matter must be given consideration, but no individual limb is necessarily determined if one may weigh more in favour than the other. What you'll notice in this particular part of the section is that there's no reference to the length of the suspension, and there's no reference otherwise in the Fair Work Act as to constrain or provide guidance on as to the determination of the suspension orders, how long it should be. So that is also something that falls within the ambit of the Commission's discretion. At paragraph 71, I've just extracted part of the quote. What the Commission found is that the purpose of a suspension order under Section 425 is to achieve a cooling off period in order to enhance the prospects of an enterprise agreement being reached and not to operate as a de facto termination of bargaining. So that's just a key point to keep in mind when considering these particular provisions. This is the last part of the section. On its face, it talks about who may make the order, who may make an application. It might seem slightly benign when looking at it, but it's quite important when you compare it to the other sections. The reason for that is because here only a bargaining representative can make the application, or alternatively a person prescribed by the regulations. Now, under the regulations, for example, in relation to a 424 application, the minister of a relevant state, and indeed in Section 424 itself, the minister can make an application themselves, or an organisation or another person directly affected by, or who would be directly affected by the industrial action, other than an employee who will still be covered by the agreement. So in other words, a third party could make an application under 424. That cannot happen here under 425. It must be the bargaining representative. Now, that was the reason why, if you cast your minds back to December 2024, there was it had a bit of media attention, but it ultimately resolved. But the Sydney Trains industrial action, at that particular juncture, there were a number of parties that made applications. It was the Minister, Laundy Hotels, Luna Park. It was the biggest stacks on you'll see in terms of trying to stop that industrial action. So it's just important to keep that in mind in terms of Section 425. There's also an important distinction in 424. An application needs to be determined within a particular time frame. You'll notice that in a few of them. That's because of the urgency of these sorts of matters. That doesn't exist in 425 either. So under 424, for example, it needs to be determined within 5 days. If that doesn't happen, then the Commission must issue a suspension order. So let's deal with the first limb, is being engaged in. That invites some contemporaneity into the analysis. As you'll see from the first point, the action must be engaged in at the time the order is made, is the short of it. There might be some argument about the level of contemporaneity, but in a nutshell, that's basically how it works. It doesn't extend to action that's threatened, impending, or probable, or any of those matters that arise under Section 424. And that's because in that particular, the TAS paper decision, Section 424, by contrast, deals with those particular circumstances. The distinction between the two sections, in that case, it was found that it would indicate that it can't extend to those particular matters. That follows that if the action is not being engaged in, or it's otherwise threatened, impending, improbable, or one of those particular elements, the Commission has no jurisdiction to deal with it, and they'll throw it out. The next limb is whether it's beneficial to bargaining representatives. Now, reasonable minds can differ as to what's beneficial for bargaining representatives, quite obviously. Ultimately, it's whether it will assist the parties in coming closer together to resolve the matter and issue. That is the ultimate task for the Commission, is that we want to make an enterprise agreement. That is the purpose of this particular section. So things that you will consider will be the state of bargaining, the nature of the particular industrial action, what is the level of escalation of the industrial action? How long has it been going on for? Are there upcoming bargaining meetings? Is there an EA about to go out to vote? How entrenched are the people or the particular parties in their positions? I've just referred again to that Sydney Trains. Clearly, I was just too obsessed when I was putting this together. I will come back to that and I will go through it. What is important, though, under this particular limb is that the bargaining representative who is making the application must provide sufficient evidence on how the suspension of the protected industrial action may assist the parties to resolve the matters in dispute. You have that evidentiary burden to make out. You can't just simply roll up and argue that the absence of protected industrial action will allow the parties to focus on bargaining. That is something that's been attempted many times and has been shut down many times. Ultimately, it's something that's inconsistent with the regime of the Act, which facilitates protected industrial action. The duration of the protected industrial action, there's not too much to this. Obviously, the more limited it is, the less likely it is that it will warrant a suspension. The longer it is, the more likely it is that there will be an order for it to cool off period. Where you draw that line will be, you will have to come up with there's a number of factors that will be involved in that. Of itself, duration is probably unlikely to be determinative. It would need to be considered in conjunction with all of the other factors, if we can call them perhaps aggravating factors, that may well then militate towards an order being made. The next limb, public interest. Again, relatively straightforward in the sense that the public interest is directed to obviously the more general concept rather than the persons affected. and something more than mere inconvenience needs to be established. Quite a similar theme. I think Faheem drew on that same exact point in the 424. It's a similar theme that comes up in both of those particular provisions. The other matter in respect of the public interest and that's been referred to is in the explanatory memorandum. I've just made a reference to it in a section point at 1709, is that these mechanisms aren't intended to be generally to prevent legitimate industrial action being taken. So it's really trying to balance those considerations of, are we going to move towards an agreement, but we also want to be able to ensure that people are entitled to take industrial action where it's legitimate. Just some examples that I've just put together. This particular case in Canberra Casino, it's probably about mid-on in terms of when these sort of applications are being brought, but there was only 17.5 hours of industrial action. And I mean, really on its face, it's pretty difficult to establish that that's going to be something you're going to suspend and need a cooling off period for. It may be something that may be the subject of a 418, but that's a very different consideration. The other consideration, that it ultimately wasn't ordered in the Near Star decision, but if it's going to have a more significant harm, then that is more likely to bring it about. So in that particular case, there was some considerations as to whether a blast furnace was going to be shut down, which would have had more general impacts on the broader community. But here that wasn't established, and so they weren't able to make the particular order. Any other relevant matters, go for your life, think whatever you could possibly think of to rope into this, but this is a highly discretionary clause. It already is, but this really just goes to show that it's whatever really the Commission wants to rope into it. One of the key matters that came up in that Sydney Trains decision is the notion of third parties. You may have looked at section 426 before, and that specifically deals with significant harm to third parties. Now, one of the arguments the union tried to mount was that third parties, the impact on third parties, could not be considered under a 425 application because there's already an express provision dealing with that. The Commission rejected that argument for two reasons. First is that under the public interest limb, you would be able to deal with it under that. And second is that any other relevant matters would encompass that. So there's no reason to read down either of those sub-provisions such that third parties couldn't be affected. You'll also see another reference to the explanatory memorandum there that provides at that particular pinpoint that there may be cases where the impact of the industrial action on the parties or third parties is so severe that it is in the public interest, or even potentially the interest of those engaging in the action, that the industrial actions cease at least temporarily. Another relevant factor that has been taken into account by the Commission is that the Commission can play a role in assisting the parties to narrow the dispute. That's another consideration that's been utilised under that particular limb. Now, I appreciate some people may or may not know the answer to this question, so if you feel confident, feel free to put your hand up. But does anyone know whether a partial suspension would be permitted under Section 425? If you want to put your hand up if you think yes, or you can put your hands and say no and just hope for the best. I had a feeling this would happen, so you can all be right. It's no. The reason for that is set out in those particular decisions. So the MUA decision at 37, what it was found was that protected industrial action is being engaged in, once it is found that protected industrial action is being engaged in, so you've reached that particular contemporaneous limb, and you've reached the state of satisfaction that the suspension of the protected industrial action is appropriate, the order that is required is one which suspends, for the duration of the order, the protected action attaching to any and all industrial action authorised under the ballot. So it's everything goes. Now, as you can see, that stands in contrast to the approach taken in respect of 424, where you can suspend particular aspects of the industrial action. The case in the MUA as well, what they said when it was advocated to the contrary position, that they said that the union's interpretation of 425 would not be consistent with the evident purpose to allow a cooling off period in the course of enterprise bargaining in order to advance the prospects of resolving the matters in issue. If a suspension order was confined in its effect to a particular type of protected industrial action taken at a particular time. That would imply that other types of protected industrial action could be taken during the cooling off period established by the order. That would appear likely to frustrate the objective of the provision, and it again raises the issue of inconsistency with section 4137. What section 4137 refers to is the common requirements of industrial action. What that provides at subsection 7 is that none of the following should be occurring, and that includes an order suspending or terminating industrial action. It also means that the 415 immunity provision, which applies in respect of protected industrial action, would not apply to that action going forward. So that, again, explanatory memorandum, the suspension or the termination of the protected industrial action brings to an end the right to take protected industrial action. Protected industrial action may be resumed after any period of suspension, but will be subject to any requirements for the giving of notice before any action may be taken. And that accords with that decision in Shell that I've just put up there, which basically says that section 425 is concerned more with the broader consequences of the industrial action per se, rather than the consequences of the industrial action in a particular context. And on the other hand, section 424 is directed at specifically preventing industrial action that is harmful or damaging. It's not directed at preventing industrial action occurring more generally. Now, I had a question about the statistics. There were 25 of these that have been handed down. Who thinks that more than half of these have amounted in a suspension order being granted? Less than half. Okay. Less than a quarter? Okay. This is my terrible table. That number of 8 is misleading for the reasons I'll come to the next slide, because at point 3 you will see that 6 of those applications related to 3 unions, oddly with West Australian newspapers. I think what had happened in that case, again, this is something I was very briefly skimming, but it was a situation where they had agreed, all of them, not to engage in industrial action. So I think there was both some claim action and some response action, and they were in the process of trying to negotiate an enterprise agreement, and perhaps they thought the best way to deal with that is just to suspend it entirely. But this was all done by consent. So very unusual. Really the only decisions that we have are the Sydney Trains decision that's just been handed down, which I would say is now the main authority on the point. The only other decision was a decision of Yallourn back in 2013, but that was issued extempore, so we don't have any of the reasons for the decision. We simply have an order, and that is it. Some other matters of note that I just referred to there was a decision in Lion Beer, Spirits and Wine. It was a bit of an odd decision in the sense that the order wasn't made on the basis that they had leave to call it back its application. It just seemed to just not even deal with the decision, but that's a very particular circumstance. And then this other one was a peculiar situation where the union again had made an application. So other than those 7 applications combined, it's largely obviously employers making these applications, but it has happened where unions have done it. Sydney Trains decision. Let's finally have a chat about that. As with any of these, trying to glean too much from the facts of other decisions really isn't of much assistance, because they are highly fact-specific and turn on the particular persuasions of the particular factual matrix. What had happened in that case was back in April of 2024, 2014 would be a long time to bargain. There had been a log of claims exchange. The union's main claims, you probably heard in the media, was that they wanted 32% over 4 years. That was been the constant dissertation from the union. There's been an extensive number of bargaining meetings. How this works in practice is that Sydney Trains bargains with what's known as the combined rail unions. If you don't know what that is, that includes the AW, the AMW, the ASU, Professionals Australia, a couple more that I can't be bothered to say. They all convene in these huge rooms and have these meetings, and they take a long time because of the amount of people that are involved. There were 90 of these big room meetings. There were then 26 working groups within that, involving a number of other representatives. There were direct meetings with the Premier, with the Treasury, with the Minister for Transport, and there were further mutual gains meetings towards the end of last year. And then there was also bargaining under the auspices of the conciliation power of the Commission. So it's a very unusual situation just in that sense in the factual matrix itself. Sydney Train started with an offer of 9.5% over 3 years. Eventually, the industrial action did work, and there was eventually an agreement in principle in respect of the first year. They brought Sydney Trains up a bit to 4% in the first year. There was agreement on that. There was agreement on 5% in the second year. The main sticking point was the third year. It was 3.5%, and it was too low for the unions. The union secretary had said that they were extremely close. I think they, in the decision it's referred to, within a whisker of agreeing. This is all how your whether your train's affected. This is how close they were to being able to resolve it. They asked for a conference before the commission to actually list it to close the matter. That's how close they were in terms of resolving this. The bargaining process was then derailed when the CRU, the Combined Rail Unions, advanced a claim regarding a $4,500 sign-on bonus. You may have seen that in the news. The point that was being made by the respective parties was that Sydney Trains was saying that this is an entirely new claim, and the union's saying, well, this already exists in the enterprise agreement. It's a rollover. This is the same entitlement. We should be entitled to it. This industrial action has also been the subject of federal court proceedings. There were 2 Section 424 applications in December and January, which I had the pleasure of being in, which resolved, and then largely because the unions had withdrawn a number of their actions. There were then Section 471 notices. For those that don't know what that is, an employer has the opportunity where someone gives a notice of a partial work ban that they may the employer may either reduce the payments for you not performing those particular tasks, or they can refuse acceptance of work in its entirety. And what Sydney Trains did in this particular most recent instance was refuse acceptance in its entirety. The union then characterised those 471 those 471 notices by the employer as lockouts. I won't get into that, but there's potentially an argument as to whether that is a conditional lockout or not, but let's not deal with that for another day. And you would have heard that there was a significant number of people that were turning up sick. That were not turning up for work because they were sick. And the bench inferred, and because of that the drivers and guards were seeking to access paid sick leave rather than attending for work and the possibility of not being paid. That's the reason why. Well, that's the inference that they made. The bench really focused on the inflammatory nature of what was going on the ground here. The union's reference to these 471 notices as lockouts, they say, provoked non-attendance. There had been mutual public recrimination, obviously, in respect of how the parties were dealing with one another, obviously significant public backlash. There'd been dissension within the CRU's bargaining group as a core, where there was one particular subgroup calling for strike action to happen across the board. The bench ultimately accepted that the protected industrial action had improved and led to continued improved wage offers over time and narrowed the gap between the parties. But what they said was that ultimately, because of what had happened in respect of this $4,500 bonus and the funding constraints of the government, amongst other things, and this inflammatory area in which they were placed, that further industrial action wasn't going to bring them any closer. And they said that when you consider the matters on the public, the suspension would obviously avoid the need for people have their lives disrupted. And also because there were particular factions within the AMW, within the RTBU, that were acting of their own volition, the bench considered that it would allow the union leadership to have an opportunity to re-establish what was referred to as a greater degree of control of events and its membership. There'd already been a number of voluntary periods of suspending action over the Christmas and New Year period, and by that they mean that the unions had agreed to suspend their action over that particular period, but then once that finished, industrial action just continued on. And so when you considered all of those factors, that was the ultimate basis for the Commission to decide that a 5-month suspension was warranted. Those are what I would say to be a highly unusual circumstances, and perhaps the reason why Section 45 is so rarely invoked. And notwithstanding that, the ETU, which for those that don't know is a union within the CEPU, they have now filed federal court proceedings. And if you've got Workplace Express, you'll be able to actually see the application on the basis that the combined rail unions were not treated as what was referred to in the application as an undifferentiated whole. And they also took issue with the funding constraints that was the findings in relation to that in the decision, and ultimately it was saying that the decision is legally unreasonable and irrational. one of the difficulties in that case will obviously be that the CRU, and it's an unusual situation, and it really arises just in respect of trains, that they bargain as a whole. So when the industrial action is terminated, it affects everyone, even if you have a different position. So the difficulty in that, one of the difficulties in that case will be that the ETU has obviously been part of the CRU. How that plays out in court will be obviously a matter for another time. The only other matter that is sort of relevant to this is extending the suspension. It's happened once. Again, in respect of that Yallourn decision, that is the only publicly available decision. Here, really, what you have to do is there needs to be an application. You can't previously have made an application for an extension, and then the commission is at large to consider anything it considers relevant, including the 425 matters. So, I think in that particular case, it was that there was going to be a ballot conducted in respect of the proposed EA, and so they thought it would be in the interests of the employer, and I believe this was also consented to. Yes, it was. And so I think the commissioner in that particular case decided to extend it. Yeah, so I think that's it. So I guess the key takeaways from that is that there's two decisions where orders have been made out of a possible 25. Yeah, and those numbers, and I think I had them in the slides, numbers may vary there, it's about right. The key issue really is that it's such a high evidentiary burden to take away someone's protected industrial action, but where there is the situation such there is at Sydney Trains, where there is prolonged industrial action that's inflammatory in nature, it's affecting the public, all of those are much more likely to be enlivened. But it's going to be far more difficult to obtain those sorts of orders, say for example in a Transgrid matter or the Wilmar Sugar matter. Perhaps the Wilmar Sugar one might be a bit easier because of the size of the sugar industry, but that's the reason why these 425 provisions are very rarely invoked. That's pretty much all I had to say. So I think really we can move on to questions. So if there's any questions for Faheem or I, I'm happy to field them. If you have none as well, that's fine with me.
I think Natalie's not there, so I don't think we have any questions online. So thank you very much to everyone for coming. We're going to stick around for a little bit, so please hang around. Feel free to grab a drink, come and have a chat to us. Otherwise, thank you very much.
Cheers. Thanks, guys.
So you have a question?
Thank you for the presentations. I don't have any questions in relation to the slides or the presentation necessarily, but in relation to bargaining process, will you also be thinking about, because I've been IBD application topics that we've got, particularly with the changes that Kevin talked about, any decisions that might be rolling out or rolled out last year? IBD.
Have we got a decision? I don't know off the top.
Yeah, there's been a number. There's been a few of them. There's been the Cleanaway decision, TW and Cleanaway. There's been there's a matter in Perth that I went over for where, so the process is you determine whether it's going to be intractable or not. And if it's intractable, sometimes these things happen by consent as well. They just agree that it's intractable and then you arbitrate the particular term. So for example, I was just in Canberra on Monday and Tuesday for the Doctors Union. They were seeking a wage increase, and also there was one other minor issue which wasn't really of note, but there was consent in relation to the IBD, Intractable Bargaining Declaration, and then you're arbitrating the workplace determination. So there's a couple of decisions that are dealing with that. There's another matter involving, again, there's the TW, the Australian International Pilots Association, a couple. Yes, Network Aviation. Yes. I appeared in the workplace determination part of that, but not the IBD part of it. So yes, still waiting on the decision for that as well. So there's a few of those that are floating around. Anything else? All right, let's get a drink then. Thanks, guys.